the state had not rejected bail. You know, the affidavit to oppose bail. Yes, sir. In opposition of bail is marred with a lot of speculation without any specification. Where the court is being invited to make a determination on the rights of the accused person. That is before the court. Without any substantive evidence. For instance, Your Honor, in paragraph 2, and I will just read in what has been written, that the matter, among others, which he is charged with before this court, involve serious offense under the law, requiring immediate judicial consideration. I do not believe there is an offense that cannot be categorized as not serious. Otherwise, it would not have been prescribed in the law. The celebrated case of Jackton, apologies for going too fast. Jackton Mutende, and the case of Michael Juma Oyamo, 2019. Gives precedence where the court said that bail cannot be denied on flimsy grounds. It must be substantiated. From this affidavit, there is nowhere that shows that the deponent made attempts to trace the accused, they also have failed deliberately have failed to inform this court when the commencement of these purported investigations were, And the last line of paragraph 4, Your Honor, states that we are apprehensive that he may abscond court. And the we, or the people, and the people described as we, Your Honor, have not been disclosed to this court. Nor will the accused person's defense team be able to interrogate whoever we is by way of cross-examination. You know, the affidavit that is before you bears tickets for Kenya Airways, a return ticket. And unless the meaning of a return ticket is not understood, I believe it shows all intents of someone traveling back. The accused before you would have returned on the 19th of January 2025 as per the documents that has been annexed in the affidavit to oppose bond. Therefore, they are well aware that the accused person has a return flight. And I do not wish to labor the court on what return means. In the way the deponent of this affidavit opposing bail has fashioned their paragraphs, it appears as though it is a crime for one to travel outside this country. Yet, not only did the accused person disclose the intention for traveling on his Twitter handle, which, Your Honor, is the first Your Honor, is the first tweet that has been captured in the annexure marked as EM2. where the accused discloses, I will read to the court, had a couple of investor meetings. Annex Chamarked EM2, the first tweet. He has disclosed what it is.
That's the request.
Yes, Your Honor.
So I avoid repeating what has already said.
Very well. Very well, Your Honor. Your Honor, traveling is not a crime out of the country. We have the passport of the accused person for the court to see that he is well traveled. And he has been traveling for a long time. It did not begin with this travel that is in contention, the one that was slated to happen today. If the court would want to peruse the passport, we have it. Court. Further, Your Honor, we have a certificate of incorporation of Flex Mobile. Which also substantiates Flex Mobi Inc. Which also shows the purpose for travel of the accused person. Your Honor, it should not be a wonder that the accused person intended to travel for business. In any case, even our government is importing labor, is exporting labor in form of people by looking for them jobs outside. So why would a businessman be told that his intention for traveling, despite disclosing it's for business, he's trying to escape the country? Your Honor, there is no single compelling reason as defined by law, any precedents, that this affidavit has deposed to warrant the accused person to be denied bail. I would be urging and praying to this honorable court to admit the accused person to reasonable bail or bond terms. And before I yield the floor to my senior, Mr. Omar'S, the certificate under Section 106B of the Evidence Act, and anywhere in this affidavit to oppose bail, you cannot confirm if Istanbul is indeed a DCI officer. I submit, Your Honor, that the certificate falls short of the threshold described in the Evidence Act. there is no information as to whether there was any alteration of the electronic device that was used. And Your Honor,
That's right.
the Constitution grants the presumption of innocence of the accused, unless otherwise proven, and as such it is not fair, and it is a matter of great prejudice to the accused person. When they make speculations as to his innocence, where they cite matters without the appropriate case numbers, where they depone
Yes, ma'am.
that it has taken them over a month to trace the accused person without giving the court and defense counsels the benefit of the excerpt of the investigation diary, for us to actually ascertain that indeed the accused has been traced for 1 month. Since he went missing. There is also no such report that the accused actually went missing. And in conclusion, Your Honor, it will be in the interest of justice to grant the accused person before the court reasonable bail and bond terms, even as he clears his name from the allegations that have been fashioned against him. Thank you.